This case was adjourned in June till November 14 for Kanu's sureties Eyinaya Abaribe, a serving senator, Ebanka Tochukwu Uchendu, and a Jewish priest, Ben El Shalom, to explain why the 100 million naira bail bond for Kanu should not be forfeited after Kanu went missing in September 2017. At the opening session on Wednesday, two of the sureties, Abaribe and El Shalom, were not in court. But the lawyer representing the Jewish priest, Aloy Ejimako, informed the court about the letter written by his client, which he claimed he had received on Tuesday. On his part, Abaribe's lawyer Chukwumama Chukwume said his client could not attend the trial because of a Senate function he was engaged in. But the judge Binta Nyako accused the sureties of neglecting the instant case and threatened to issue a bench warrant against the sureties. This ushered in a dramatic scene, and the lawyer representing Uchendu was forced to inform the court about the presence of his client. Justice Nyako became calm and decided to temper justice with mercy by withdrawing the bench warrant and replacing it with an order of the forfeiture of the bail bond by the three sureties, which is 300 million naira.
You are aware of the issue involved, that there is an Nnamdi Kanu that is found in Israel. We don't want the court to work with such an issue. There need to be factual. So we have written a letter to the ambassador of Nigeria in Israel, asking them to find out whether the Nnamdi Kanu that is said to be there is the same Nnamdi Kanu that is supposed to be before this court. When we have that reply, we will now take off from there, because there is need to inform this court properly. Already a suit has been ignited on the basis of that unfounded information. And so we don't want this court to throw that line of going with unfounded information.
We are moved by the magnanimity of the court. You're all witness to what the court did say. And of course, the court has been so magnanimous with the sureties. But all the same, we believe that this is a process to achieving justice of this matter. We also believe that court is a court of justice, and is given the opportunity for all that are before it to enjoy the justice that is embedded in the court. And so the order given by the court for the sureties to deposit the sum of the bail bond is a fair one. And as you are all aware again, 2 months is given within which that money should be deposited.
Justice Nyako ordered them to pay the money immediately or risk getting arrested.
We rightly observed before the court that the sureties have different applications before the court to show cause on why the order of official will not be made. And the order the court made tantamount to putting the cart before the horse, because those applications have to be had and disposed of before an order will be made. So, and I believe the lawyers for the sureties know what to do to that effect. The court gave them 6 months, and the matter is coming up on the 28th of March 2019 for the hearing of different applications filed by the sureties. And I'm very firm that at the end of the application, that the court will most likely change take a different view on the order he made today, because what we are talking about is what is responsible for his not appearance in court to defend the suit. That's fundamental, and it's no longer in doubt as to what happened in his house on the 14th of September 2017. The military invaded his house in the course of enjoying his bail conditions, killed people therein. So, and the court needs to, in the first place, make inquiry as to what led to that invasion. Because under normal circumstances, he was ready to be in court. So what would have happened had he was killed? That's a fundamental question. Because that's the area we want the court to understand. And that has presented a situation which is beyond the control of the sureties for him to be in court today, or to continue to stand for trial until when security is guaranteed. Because he would have already been killed from the facts already made available to the public on what transpired in his house on that day. Otherwise, why are they in his court? The military, they are also serving the same federal government, and they are aware that this matter is coming up on was scheduled to be heard on the 27th day of October 2017. Why didn't they wait for him to come to court? They were arrested. They would have come to court and arrested him, or possibly extend invitation to him for him to appear before either the SSS or the police, if at all there's any allegation against him for commission of any offense. But they didn't do that. So that shows you that the intention of invasion of his house on the 14th of September 2017 was nothing but to go and kill him. That's nothing more. Because if they had wanted him, they were waiting for him to come to court. And before then, he has announced to the world that he's coming to court on October 27th to face his trial. So why taking war to his house? So these are circumstances the court has to listen to. How are you sure that if it's the court today, they will not kill him?
Preferred constitutional applications before this court to afford my client the opportunity to be heard on the question of non-appearance of the defendant in court. So my argument is very simple and is a matter of law recognized under the federal rules of civil procedure and also under the Administration of Criminal Justice Act and Nigerian Constitution, that taking someone on bail and then the defendant appears to have breached the bail by not appearing in court is not a strict liability matter. The surety deserves a day in court. The surety deserves to be heard as to the circumstances that forced or compelled or created the non-appearance of the defendant. It's only when the court has considered the circumstances in a full evidentiary hearing that it can be said in law that the defendant has John bail. Until that determination is made, the mere non-appearance of Nnamdi Kanu is not sufficient for any court of law to hold that as a matter of law he John bail. So his surety deserves a chance, an opportunity before this honorable court to be heard on the proposition that someone came from somewhere. A third party not privy to this contract of bail between the defendant and the court emanated from somewhere. That someone is the Nigerian Army. And Nigerian Army is qua Federal Republic of Nigeria, and it's the Federal Republic of Nigeria that has Nnamdi Kanu in its court. So someone came from somewhere and snatched the defendant. This is what needs to be heard. Until that has occurred, I don't think it comports with fundamental fairness principles and the Constitution of the Federal Republic of Nigeria that the sureties shall be held liable to forfeit their bond.
The judge reiterated that the order directing the sureties to pay the money was an order of interim forfeiture. Meanwhile, the trial of Kanu's accomplices was stalled due to the absence of the prosecution witnesses. Kanu's trial continues on March 28, 2019. Emmanuel Bagudu, PTV News, Abuja.